All rise, www. Please be seated for Vosva.
Good morning, everybody. Could the court officer call the case, please?
The special session marking the formal opening of the Judicial Year 2023 is now open. La session spéciale de la Cour pénale internationale marque l'ouverture officielle de l'année judiciaire 2023 est maintenant ouverte.
Thank you very much. Dear fellow judges of this court, dear Madam President of the International Court of Justice, dear presidents of other international and national courts, dear colleagues from the national, international, and regional jurisdictions, Mr. Under Secretary General for Legal Affairs and Legal Council of the United Nations, Madam Vice President of the Assembly of State Parties, Mr. Prosecutor, Mr. Registrar, Madam President of the ICC Bar Association, esteemed representatives of states and civil society. I offer you all a warm welcome to this solemn hearing on the occasion of the opening of the Judicial Year 2023 of the International Criminal Court. We are particularly honored by the presence of many presidents of international and regional courts and chief justices of national jurisdictions of state parties to the Rome Statute who have taken time from their busy schedules to be with us today. As we pause for a moment to reflect on our mandate and renew our commitment to justice, it gives us strength to see so many esteemed colleagues by your side. 2023 will be a very active year for the International Criminal Court. But before discussing what lies ahead of us, let us take a brief look at the year behind us. 2022 was, on all accounts, the busiest year yet in the ICC's history. Despite of the fact that we commenced last year still very much in the minds in the pandemic, the court was very active all along, holding regular hearings even when heavy restrictions on physical interaction were still in place in the Netherlands. By the beginning of last summer, we were finally able to return to working wholesale physically here at the court premises. I will not say back to normal, because in the meantime, normal had changed to some extent. We learned during the pandemic that we can, in fact, do a lot on efficient and effective work remotely as well. With this realization, the ICC introduced more flexible rules of remote and hybrid working methods to support staff well-being. Nevertheless, we cannot function entirely without a physical environment where we see each other on a regular basis. It is a big part of who we are as a team. And as I believe colleagues would agree, court hearings are still most effective when all participants can see each other face to face. Excellencies, ladies and gentlemen, in 2022, a record number of 1,029 hours of courtroom hearings took place at the ICC. And the year ahead of us is likely to be as intensive as the last one. 3 trials are in full swing. 2 of these concern the situation in the Central African Republic too. These are the Yekatom and Gaisona trial before the trial chamber 5 and the Said trial before trial chamber 6. And the situation in Darfur, Sudan, the trial of Mr. Abd al-Rahman is taking place before trial chamber 1. Furthermore, in the situation in Mali, the trial chamber 10 is hearing the Al Hassan case, which is approaching its final stages in the form of closing remarks. And more work is in the pipeline. The hearing on the confirmation of charges in the Mokom case concerning the Central African Republic is scheduled to take place in the near future. With several new arrest warrants issued last year, there are now outstanding warrants or arrests against 14 individuals in total. I urge all states to do their utmost to secure the appearance of these persons before the court without delay, so that they may answer the allegations against them in an impartial and independent court of law. Indeed, the full cooperation of states is critical for the ability of the ICC to carry out its mandate. States also play a crucial role in the fight against impunity through the national justice system, which have primacy under the principle of complementarity enshrined in the Rome Statute. This also applies to reparations for victims, which are an essential part of redressing the gravest crime under international law. It is first and foremost the domestic courts that must be the vanguard against impunity, and only when they cannot or will not act, the ICC should intervene. And domestic courts are also the ones that must carry on the torch of justice once the ICC's intervention ends. Indeed, the strengthening of national courts to address genocide, crimes against humanity, war crimes, and crime of aggression is of utmost importance. This was underlined in a very concrete way when the prosecutor of the ICC announced the end of the last year to closure the investigation stage and situation before the court for the first time in Central African Republic and Georgia. The ICC plays a key part as the norm barrier of international criminal justice, but we can approach closing the gap of impunity only when the national jurisdictions are equipped to effectively address international crimes. Against this background, we have devoted this year's judicial seminar to the role of national courts in the international criminal justice system. The judicial seminar, a tradition since 2018, just like this ceremony, brings together the judges of the ICC with judges from national, international, and regional jurisdiction for a frank discussion and an exchange of views on a topical issues of choice. While the seminar itself is a closed event, a public summary report will be issued due course. Excellencies, ladies and gentlemen, before I give the floor to the prosecutor to make remarks, we will hear a musical intermezzo performed by duo Van Hees Venstra from the Netherlands with Ms. Jantine Venstra on the basson and Martien van Hees on the guitar. They will play for us the piece Café 1930 by Astor Piazzolla. Please. Thank you for this beautiful performance. I now give the floor to the prosecutor of the International Criminal Court, Mr. Karim Khan. Please, you have the floor.
Dear Mr. President, honourable judges of the International Criminal Court, respected President of the International Court of Justice, our very dear, very welcome guest of honour, Under Secretary General of Legal Affairs and Legal Counsel, Miguel de Silva Suarez, dear Mr. Registrar, members of the Diplomatic Corps, ambassadors, President of the ICCBA, and dear Deputy Prosecutors and friends. It really is a privilege and a pleasure to be able to say a few words on the opening of this judicial year. And it is perhaps, of course, opportune that the opening of the judicial year coincides with the start of the year. It is a moment, of course, to pause and to reflect on the achievements, challenges and difficulties of last year, as the President mentioned, before driving forward with the demands and the objectives that lay before us in the year ahead. 2022 was challenging. The effects of COVID continue to reverberate, and many of us, many of our colleagues, and many of the individuals in the audience or watching have felt profound loss, have had many difficulties in their private life, and also in the professional way that they have tried to discharge their responsibilities in this court so admirably. But I do think that the progress made has allowed us and must force us to move to a higher vantage point, to better see the challenges ahead and the opportunities to succeed, which we must very keenly grasp. The fundamental obligation, of course, for everybody involved in the rule of law, in any judicial system, anywhere in the world, is to independently and impartially discharge one's mandate. And the focus of 2023, with the greatest of respect, the purpose of today, it is not to put the spotlight on us, on this building, on this courtroom, or even in the extremely generous, on the extreme generosity on this wonderful city of The Hague. It must be to focus on those victims, those survivors, those fellow travelers of humanity that look to these institutions that we have the honor to be part of to actually deliver, to make a difference, to show that the law has the capacity to cascade out of rooms such as these, hallowed halls of justice, and affect the lives of individuals in a way that they can sense, that they could feel, and that fortifies the relevance of international law, not as an abstract concept, but as something absolutely vital as an anchor for human rights, peace, stability, and security. Complementarity, in fact, requires of all of us such a broader horizon of understanding. And I think, Mr. President, to hear that the focus of the workshop at the judicial seminar is precisely that, is with the greatest of humility and respect and absolutely an extremely wise focus. Because as we speak, millions crave justice. They hunger for justice in the same sense. They hunger all too much in so many different places. This year, we will continue in the office to further attempt to build bridges, to narrow the perceived distance between international justice and indeed the actual physical real distance between the ICC and the affected communities that we have to serve. I think this will be a truly exciting year, God willing, as we try in the office to improve our own efficiency, to work together with the deputies and with every man and woman in the office, with our colleagues in the registry, in the ICCPA, and with the greatest respect, judges as well, so collectively and independently we can get the results. This year we'll see, throughout the year, an acceleration as we seek to deploy innovation and technology to serve the common good. This is not only to try to bring more vividly the crime scene to the courtroom, but to use technology, artificial intelligence, machine learning, voice-to-text, transcription services, automated translation services, in a way that drastically and dramatically improves our ability to ingest evidence. This isn't, with respect, an issue for geeks. This is not, with respect, something that is irrelevant to international justice. It is my considered opinion, Mr. President, this will have the capacity to improve significantly our obligation under the statute to investigate incriminating and exculpatory evidence equally, because by receiving more information and evidence, using those tools, partnering also with the court, other court users, including the ICCBA, we can hopefully make sure that we improve the quality of evidence we present for your own consideration. We can understand what takes place and what it actually means. In the course of the year, I will seek to reach out to all court users to also propose and discuss and hear about new processes regarding disclosure that will be imperative as we start receiving new evidence and using technological assisted review that is used in so many different jurisdictions because of the phenomena that we receive of mass data sets that have to be grasped and fundamentally understood. Mr. President, before I conclude, I think it's also important to identify the importance of continued progress on the march towards gender equality and geographical diversity, to build upon the really important strategy on gender equality and workplace culture that we collectively launched only last month at the sidelines of the Assembly of State Party. Not only because it's needed and it improves the workplace environment, but to apply international law, we must realize it is not the preserve of any one region, any one country, but is the collective heritage of humanity. And by having individuals from all disciplines, from all parts of the world, from all legal traditions, we will improve the application of the Rome Statute better, we will understand situations more acutely, and we will make the law more relevant. This, of course, is the 25th anniversary of the signing of the Rome Statute. It does present an opportunity to all, not just the organs of the court and the users of the court, but the international community who in Rome committed to breathe life into the statute, to strengthen it, make it more relevant, and in the same way we are seeking to reduce the gap between the court and the affected communities, with your help, to reduce the gap between the promises and commitments states have made and the actual delivery of support, which has been promised not to us as elected officials, but has been promised to the most vulnerable individuals on this planet. It is not only a legal requirement of the statute, it is a moral imperative. Mr. President, guest of honor, dear Miguel, judges, colleagues and friends, I look forward to working with all of you. My whole office looks forward to working with all of you to improve delivery and discharge our own responsibilities to vindicate the prayers, the hopes, and the expectations of the survivors of so many crimes that continue to be committed. Thank you so much.
Thank you very much, Mr. Prosecutor. I now invite the President of the ICC Bar Association, Madame Marie-Hélène Pro, to make remarks.
Monsieur le Président de la Cour,
Your Honour, Your Honours, President of the Court of the International Court of Justice, Vice President of the Assembly of States Parties, Honourable Judges, the Under-Secretary and Legal Advisor of the United Nations, Prosecutor, Registrar, Your Excellencies and dear colleagues, it is an honour for me to be able to address you today in my capacity as President of the ICB. The opening of the new judicial year takes us to reflect and appreciate the importance of the ICC, its desire for universality and its central role in the system of international criminal justice. And among the actors who are at the very heart of the work of the court, there are of course the lawyers, the defence, and for victims as well. The court cannot fulfill its mission without the devotion, sacrifice, and hard work of its lawyers. The lawyers and the members of their teams play an absolutely essential role in the judicial process of the court. And as you know, external counsel and their teams work in difficult conditions, but with great and unparalleled conviction. The prejudices against the counsel of the defence are fierce, and sometimes they have an unpopular role to fulfil. They fill that role with profound conviction, the profound conviction that all justice is impossible without an acute defence of the rights of the accused, and they are the guard dogs of a fair trial, which of course includes the equality of arms, which is often put in threat, but is fundamental for the legitimacy of the court. The legal representatives of victims, for their part, are moved by the suffering and the expectations of their clients. They bear their hopes for a better future. This is a heavy burden with significance and meaning, and their mandate is anchored in the real trauma of victims and in the universal concept of humanity.
Enter into this new year, I want to pay tribute to the contribution of counsel and of their support staff. The ICCBA is proud to represent them and to voice their concerns and their demands before the organs of the court, the ASP, and the general public. As you know, these last few months have been a turning point for members of external teams. Late last year, support staff of defense and victims teams have launched labor actions, including a 5-day strike. As of today, they are still being denied basic labor protection after years of negotiations have failed to secure them. But I'm hopeful that this is the year we find the necessary solutions. This is the year that we will create a renewed system of supporting the defense and victims teams in their critical work to ensure the ability to continue fulfillment of the court's mandate, justice. There can be no justice without a strong defense and without meaningful representation of participating victims. And there can be no fair trial without equality of arms. But we are not able to make the necessary changes alone. As the ICCBA continues to advocate on behalf of external teams, I humbly turn to you for support. I hope that you can see us as your partners in justice, and that defense and victim team members are proud to contribute to the court's mission. This year, with your recognition and support, they can continue to strive for the highest level of competence, ethics, and effectiveness in the full representation of their clients. Thank you.
Thank you very much, Madam Pro. The next speaker is the Registrar of the International Criminal Court, Mr. Peter Lewis. You have the floor, Mr. Registrar.
Madam Vice President of the Assembly of States Parties, Mr. President of the Court and Vice Presidents, Your Honours, Mr. Prosecutor and Deputy Prosecutors, Madam President of the ICC Bar Association, Your Excellencies and distinguished guests, and colleagues from the Court. It's a great honour to address you today on the opening of the 2023 Judicial Year. As my colleagues have said, the opening of a new judicial year is an opportunity to reflect on the year behind us, as well as looking forward to the year ahead. 2022 was a year of substantial judicial activity, with significant pre-trial and appellate work, as well as the opening of a third courtroom to accommodate 5 trials and new reparations work. This substantial judicial caseload was successfully managed because of the hard work, resilience, flexibility, and resourcefulness of the people of the court, and the assistance of those who support us, including, in particular, the United Nations. Managing last year's caseload included supporting 125 witnesses to give evidence, which included 52 witnesses giving evidence by video link, conducting 25 certifications for prosecution and defense witnesses from across the world, providing temporary protection to 118 witnesses and their 590 dependents, finding effective relocation for 13 witnesses and trying to find solutions for 21 other victims in desperate need of relocation, supporting 132 missions for the defense and legal representatives of victims, providing 6 family visits for detainees, making more than 170 requests for cooperation to states and the United Nations, providing interpretation for court hearings, conferences, field and operational missions, and responding to more than 1,500 requests for translation. And the languages we provide these services in: Acholi, Burmese, Dari, Fur, Georgian, Kirundi, Pashto, Sango, Songhay, Sudanese Arabic, Congo Swahili, Tamashek, and the list goes on. We support more than 26 languages, all the official languages of the UN, and of course our 2 languages, English and French, our working languages of the court. Supporting more than 6,000 requests for victims to participate in the hearings and proceedings for the first time, leading to a total of more than 13,000 victims participating in ongoing proceedings, and holding 291 public court sessions. Now, looking forward to the year ahead, we have many challenges to meet. 2023 will be the busiest ever in terms of judicial activity, as the President has said, with at least 3 simultaneous trials throughout the year. We will be involved with reparation work in the largest cases the court and the Trust Fund for Victims so far encountered. And as the court moves into new situations and on new continents, new cooperation partnerships will be needed to be established. When we, the people of the court, face these new challenges, we will do so knowing we have proved our capability, resilience, and responsiveness. We have the strong support from our states' parties, other states, and the United Nations and civil society. But above all else, we face 2023 with the knowledge that for those victims and communities who thirst for justice and peace, what we do here matters. Thank you.
I thank the Registrar, Mr. Peter Lewis, for his remarks. As this is the last appearance in this annual ceremony, I also take the opportunity to recognize his stellar service at the ICC during his mandate, which is coming to end on the 16th of April this year. His contributions to the strengthening of the court's operation will have a long-standing legacy, and his successor, whom the judges of the court will elect next month, will have really big shoes to fill. Thank you, Mr. Registrar. And I will now invite duo van Hess-Wenstra to perform for us a second time. They will play a medley consisting of two pieces, Nana by Manuel de Falla and the traditional Sherelle. Please perform. Thank you. Thank you very much for the fantastic performance. Thank you. I now have the great pleasure to introduce today's guest of honor and keynote speaker, Mr. Miguel de Sharpa Suarez of the United Nations Under Secretary General for the Legal Affairs and UN General Legal Counsel, having been appointed to that position almost 10 years ago in August 2013. At the helm of the UN Office of Legal Affairs and as a member of the UN's Senior Management Group, Mr. Sharpa Suarez plays a key role in the dynamic relationship and multi-faceted cooperation between the International Criminal Court and the United Nations. I believe I speak on behalf of all of us when I say that we are very much look forward to hearing his keynote speech. Mr. Sharpa Suarez, you have the floor, please.
Your Excellency, Judge Ofmansky, President of the International Criminal Court, honorable judges, Your Excellency, President of the International Court of Justice, Judge Donoghue, and other distinguished representatives of international and national jurisdictions, Excellencies, I am very pleased to address you today at the occasion of the opening of the Judicial Year of the International Criminal Court. This past year and this year are important years for the Court as they respectively mark the 20th anniversary of the entry into force and the 25th anniversary of the adoption of the Rome Statute. And these were defining moments in international law and international relations, a momentous accomplishment earned through relentless effort, one that even some of the most fervent supporters of the cause of international criminal justice had barely dared hope to see in their lifetime. The United Nations played a significant role in the establishment of the ICC and has provided unwavering support for the Court as an independent and impartial judicial institution ever since. With each passing year, our relationship has grown stronger. Today's occasion, therefore, seems particularly fitting to recall the long history of the close relationship between the United Nations and the Court from its outset. Some attribute the creation of the Court to the 1989 resolution of the General Assembly on transnational crimes and the establishment of an international criminal court with jurisdiction over such crimes, which revived the negotiation process that had been stalled for decades. Indeed, the 1989 resolution itself refers back to the work of the International Law Commission on a draft code of crimes against the peace and security of mankind, which started in 1947. One of the questions to be considered by the International Law Commission was, in fact, the creation of such a court. It was again a resolution of the General Assembly which convened the United Nations Diplomatic Conference of Plenipotentiaries on the establishment of an international criminal court, which ultimately, as you all know, adopted the Rome Statute on the 17th July 1998. So in order to truly appreciate the magnitude of this achievement, it may be recalled that it came 50 years after the adoption by the General Assembly of the Genocide Convention, which had embraced the concept of individual criminal responsibility and in its Article 6 included the idea of an international penal tribunal to try persons charged with the crime of genocide. With the adoption of the Rome Statute, this article finally found purpose. In practical terms, the synergies between our both organizations have been envisaged since the inception of the ICC. The creation of the ICC signaled a desire to strengthen the linkages between international justice and international peace and security. The drafters of the Rome Statute always envisaged a vital role for the United Nations in support of the Court and its work, and this is evidenced in a number of ways. The statute provides for the United Nations Security Council to refer situations to the prosecutor and to be able to request and secure the deferral of investigations and prosecutions. To date, the Security Council has referred two situations to the ICC, Darfur in 2005 and Libya in 2011. Furthermore, under the statute, the Secretary General also plays an important role by acting as the depositary of the ICC's founding instrument, a function that is carried out by my office. Most importantly, however, the statute provides for the Court to be brought into relationship with the United Nations through an agreement. And the relationship agreement between the United Nations and the Court was concluded in 2004. It is founded in a shared belief that the cause of peace can only be served if those responsible for the most serious crimes of international concern are brought to justice. Excellencies, ladies and gentlemen, since the ICC's establishment, the United Nations and the Court have enjoyed a strong and steadfast relationship. The relationship agreement has proven to be a solid foundation for our cooperation, and it provides for a general and mutual obligation to cooperate and contains several provisions which guide the United Nations assistance to the ICC. The Office of Legal Affairs, which I have the honor and privilege to lead, acts as the focal point within the organization for cooperation with the Court. And in order to ensure that our cooperation remains strong and efficient, our institutions have engaged in continuous dialogue, stock-taking, and lessons learned over the years. I look forward to continue these constructive discussions with the Court's principals. As the Court has steadily increased its workload, so has the cooperation between our institutions. Indeed, my office has seen a clear increase in cooperation requests over the years from all organs of the Court. The extent of the requested cooperation has expanded not only in terms of volume, but also in terms of its nature and geographical scope. As the Court is increasingly operating in a growing number of countries across multiple continents, it has requested assistance from an ever-growing number of United Nations offices and entities, both at headquarters and field levels. And my office has been liaising and advising these offices and entities, including country offices, resident coordinators, independent mandate holders, such as special rapporteurs and commissions of inquiry on the procedures and principles which guide the organization's cooperation with the Court. Similarly, with the evolution of the Court's activities and the expansion of its proceedings beyond the investigative phase, including multiple trial and reparations proceedings, we have noted an increasing number of requests from across the Court spanning across these different phases. And the nature of these requests has naturally also evolved, often presenting an array of unique challenges and sensitivities. However, most of the cooperation that the United Nations extends to the Court, as you will readily appreciate, usually takes place in a confidential and discreet but efficient manner, and predominantly outside of the public light. The principle of discretion is one of the guiding principles of our ever-growing cooperation, and indeed, the full extent of the cooperation that the United Nations has been extending to the Court in the last 2 decades is almost impossible to measure or quantify. The cooperation requested from the United Nations relates predominantly to the provision of United Nations documentation and information, access to United Nations personnel, and the provision of administrative and logistical assistance in the field. And as envisaged by the relationship agreement, numerous memoranda of understanding, exchanges of letters, and other arrangements have been concluded regarding the cooperation between various United Nations entities and the International Criminal Court. For example, several peacekeeping operations have concluded memorandums of understanding with the court, resulting in expedited and streamlined procedures for handling court requests for administrative and logistical assistance in these countries. In the last 2 decades, the United Nations has provided an extensive amount of documentation and information to the different organs of the court. Each request for access to and disclosure of United Nations information involves a careful assessment in order to identify and address any sensitivities or concerns. And this often involves complex discussions on discrete legal points to find mutually acceptable solutions. My office provides guidance to the substantive officers with a view to ensuring that our own legal framework is adhered to, while making every effort to cooperate to the fullest extent possible with the court, in line with our obligations under the relationship agreement and our shared goal of promoting justice and accountability. Similar considerations often relate also to requests for access to United Nations personnel, whose presence in the field and unique expertise make them invaluable to the court's investigations and prosecutions. The United Nations has made a very large number of its personnel available to the Office of the Prosecutor as well as to defense counsels, regularly facilitating their interviews and testimonies in the proceedings before the court. Indeed, a United Nations staff member was the first person to testify before the court in its first trial, that of Thomas Lubanga. The requests for United Nations expertise have not been limited to the investigative and trial phases. In relation to reparation proceedings, United Nations experts have been repeatedly called upon to provide expert testimonies on the impact that the crimes for which the defendant was found guilty had on victims and affected communities. Notably, in February 2022, on behalf of the United Nations and the number of its officers and entities, I made a joint amicus curiae submission in the reparations phase of the case against Dominique Ongwen, with a view to sharing our unique experience and expertise on the specific needs of and considerations for victims, particularly in relation to sexual violence in conflict, in order to assist the Chamber in its deliberations. These interventions further attest to the commitment of the United Nations, my office, and my personal commitment to the advancement of international criminal justice, including through the continuously developing ICC jurisprudence. More generally, the United Nations' own activities and the mandates which it receives from its political organs increasingly and explicitly recognize the important role that the court plays in the fight against impunity, in its resolutions setting out the mandates of the United Nations peacekeeping missions in the countries where the ICC has an active investigation. The Security Council has reiterated the urgent and imperative need to hold accountable all those responsible for acts which may amount to crimes under the Rome Statute, and has urged the governments to cooperate with the court. And the more recently established international non-judicial accountability mechanisms play a particularly relevant role of sharing information with judicial institutions. Now, these mechanisms are tasked with collecting and preserving evidence of atrocity crimes for future proceedings. in accordance with the highest standards in light of judicial scrutiny. Several of them are mandated to support judicial proceedings before national, regional, and international courts. And the independent investigative mechanism for Myanmar, which was established after the ICC prosecutor opened an investigation into the situation in Bangladesh, Myanmar, is explicitly tasked to support the court's efforts. Excellencies, ladies and gentlemen, today the International Criminal Court is a fully functional international judicial body, a fact of international life, and part of the architecture of international criminal justice. At the same time, however, almost 25 years after the adoption of the Rome Statute, the Court, as any solid long-term project, still remains a work in progress, like the United Nations. The abiding challenge for the Court remains to realize its full potential in its fight to end impunity and build a just and more peaceful world. Its work, and in particular the judicial decisions, are the focus of the attention of the international community, now possibly even more than ever before. And the enduring value of the Court will be assessed in light of its capacity to react and to adjust itself to the very many challenges that it faces. Although the International Criminal Court is just one element of the international justice system, which encompasses other courts, tribunals, non-judicial mechanisms, as the Secretary General stated last week in the Security Council, and I quote, "Today, the International Criminal Court is the central institution of the international criminal justice system," end of quote. I echo this sentiment. The role of the Court is invaluable to our shared goal of ending impunity for the most serious crimes of concern to the international community as a whole. We must not forget, however, that the strength of the ICC depends on the support it gets from the states parties, and in the words of former Secretary General Ban Ki-moon, I quote, "There can be no alternative. We cannot say that we fully support ending impunity for such crimes while standing apart from the very institution that has been established to achieve that goal," end of quote. The success of the Court in fulfilling its mandate is the only way to ensure that the integrity of the international criminal justice system is maintained and sustained for a long time to come. It is in all our interests, state parties, non-state parties, international organizations, and civil society alike, to support the ICC in achieving its goals. The ICC represents our best hope for ensuring that those who commit crimes that shock the conscience of humankind are prosecuted and that justice is served to the victims. The United Nations is committed to continue to support the work of the Court and looks forward to witnessing its growth as it solidifies its position as the pillar of the international criminal justice system. I am very confident that the relationship between the United Nations and the International Criminal Court will continue to grow, and I look forward to our ongoing close collaboration in the upcoming year. The Court will always find in the United Nations a committed partner, a staunch ally, and a firm friend. Allow me, last but not least, to say farewell to Peter Lewis, the Register of the institution, with whom I have a wonderful working relationship. Thank you, Peter, for all the friendship and the good work together. And I wish you the best in your future professional endeavors. Thank you very much for your kind attention.
Mr. Sherpa Soares, dear Miguel, thank you very much for this wonderful speech. You have given us a powerful reminder of a profound connection between the United Nations and the International Criminal Court, as both organizations strive to serve the common cause of humanity as a whole. Our partnership remains as important as ever as we embark on the ICC third decade. I take this opportunity to thank you for the invaluable support you have personally provided the court during your tenure, and I thank you once more for addressing us today. Dear colleagues, excellencies, ladies and gentlemen, we have arrived at the end of this solemn hearing. I am truly grateful that you have shared this brief hour on reflection with us. I invite everyone present to play their part in support of international criminal justice with renewed energy in the year ahead of us. On behalf of the judges of the International Criminal Court, I pledge the fullest commitment to the independence, impartiality and fairness of the proceedings before this court. I hereby declare the Judicial Year 2023 of the International Criminal Court opened. The hearing is adjourned.
All rise, veuve lever.